to explain the bill.
Thank you, Mr. Speaker. Members, House Bill 4 is a landmark border security bill that provides a Texas solution to a Texas problem. House Bill 4 creates a state offense for entering or attempting to enter the state illegally.
Ms. Weiner, for what purpose?
Mr. Speaker, I rise on a point of order against further consideration of HB 4 under Rule 8, Section 1A, that the caption fails to give reasonable notice of the subject of the bill.
Please bring your point of order down front. Recognize Mr. Spiller to explain the bill.
Thank you, Mr. Speaker.
Ms. Neave-Crowder, for what purpose?
Does the gentleman yield?
Well, if you would, let me finish my layout, and then I'll be happy to.
Sure, thank you.
Gentleman, yield just a moment. Thank you.
Members, we have a crisis at our southern border. An unprecedented number of people, including a growing number of documented terrorists, drugs, weapons, continue to illegally cross our southern border into Texas. Governor Abbott, the Texas Department of Public Safety, and the Texas National Guard continue to work together to secure our border and to prevent, detect, and interdict transnational criminal behavior between the ports of entry. Since the launch of Operation Lone Star, the multi-agency effort has led to approximately 500,000 illegal immigrant apprehensions, approximately 35,000 criminal arrests, and more than 31,000 felony charges reported. In the fight against fentanyl alone, Texas law enforcement has seized over 429 million legal doses of fentanyl. Texans know that the Biden administration has failed and refused to enforce federal immigration laws and to secure our border. Mexican drug cartels continue to traffic fentanyl and other illegal drugs into our state and our country, and to continue to traffic men, women, and children to be held into servitude to them. Our cries for help and enforcement of our existing federal immigration laws have been ignored by President Biden. We have had enough. House Bill 4 addresses the problem head-on. House Bill 4 is a landmark bill that allows Texans to protect Texas, to send illegal immigrants back, and to prosecute and incarcerate those that refuse to leave. Under House Bill 4, for the first time ever, Texas will subject people to detention and arrest for illegal entry into our state from a foreign nation. All licensed law enforcement officers in Texas will be authorized to arrest or remove any person who illegally enters the state, with penalties of up to 20 years in prison for refusing to comply with an order to return. Let me take a moment, if I will, to explain the bill. There have been a lot of questions. House Bill 4 specific provisions are summarized as follows. Chapter 51 is added to the Texas Penal Code. That section 51.01 defines alien and port of entry as those terms are defined under existing federal law. Section 5102 provides for the offense of illegal entry from foreign nation, stating that a person who is an alien commits an offense if the person enters or attempts to enter this state from a foreign nation at any location other than a lawful port of entry. First offense is a Class B misdemeanor. This language, by the way, is nothing new. It tracks existing federal law, 8 U.S.C. 1325. Additionally, so as not to conflict with existing federal law, this section provides an affirmative defense to prosecution if the federal government has granted the defendant lawful presence in the United States or asylum, the defendant's conduct does not constitute a violation of 8 U.S.C. 1325, or the defendant was approved for benefits under DACA, the Deferred Action for Childhood Arrivals program. However, under subsection E of the provision, a peace officer may, in lieu of arrest, remove a person detained for a violation of the section by collecting their identifying information, transporting the person to a port of entry, and ordering the person to return to the foreign nation from which the person entered or attempted to enter. This process is similar to existing federal law, providing for removal under 8 U.S.C. Section 1225. Then, under Section 5104, a refusal to comply with an order to return to the foreign nation from which they entered or attempted to enter is a second-degree felony punishable by 2 to 20 years. Further, Section 51.03 provides for the offense of illegal re-entry by stating that a person who's an alien commits an offense if the person enters, attempts to enter, or is any time found in this state after, 1, being denied admission to or excluded, deported, or removed from the United States, or 2, having departed the United States while an order of exclusion, deportation, or removal is outstanding. That offense is a Class A misdemeanor, but provides for an increased penalty based on prior convictions or removals. Again, this language is nothing new. It tracks existing federal law, 8 U.S.C. Section 1326. Section 2 of the bill amends the Civil Practice and Remedies Code by adding Chapter 117 dealing with indemnification relative to enforcement of these rules. That's at the local level, and then again, Section 117.003 provides the same indemnification language relative to state officials. And lastly, 17.004 provides that for a civil action brought under either of those provisions, an appeal must be taken directly to the Supreme Court of Texas. Now, why House Bill 4 and why is this bill structured this way? First, I believe House Bill 4, unlike some other prior proposals, is completely constitutional. It's not in conflict with the precedent set in the Arizona versus United States case. It's completely distinguishable from the statute that Arizona passed, and is not preempted by existing federal immigration law. What Arizona attempted to do is completely different than what Texas is doing under House Bill 4. Second, House Bill 4 is not preempted by federal law because it's not in conflict with federal law. To quote from the majority opinion in the Arizona case, state laws are preempted when they conflict with federal law, including when they stand as an obstacle to the accomplishment and execution of the full purposes and objectives of Congress. House Bill 4 goes to great lengths to avoid that. Third, House Bill 4 is the first time ever Texas will subject people to detention. Lastly, let me say this. Third, Texas has a constitutional right and authority and ability to protect its borders. And fourth, House Bill 4 is the Texas solution to a Texas problem. It is a humane, logical, and efficient approach to a problem created and fostered by the Biden administration's continued failure and refusal to secure our border. Not only does it not overburden our criminal justice system, it should be less costly than detaining many people that we're currently expending funds to house. There is nothing unfair about ordering someone back from where they came if they arrived here illegally. House Bill 4 tracks existing federal immigration law that's been in place for decades. Further, House Bill 4 protects and supports our Texas law enforcement officers and gives them the tools and authority they need to help keep us all safe. I applaud Governor Abbott for adding this issue to the special session. Texas needs House Bill 4.
Ms. Ortega, for what purpose?
I raise a point of order against further consideration of House Bill 4 on the grounds that the bill violates Article 3, Section 40 of the Texas Constitution, as a provision in the bill is not included in the call by the governor of the state of Texas for the third session of the 88th Texas Legislature.
Please bring your point of order down front. Ms. Niave Criado raises a point of order against further consideration of HB 4 under Article 3, Section 40 of the Texas Constitution on the grounds that the subject matter of the bill is not included in the governor's proclamation. The proclamation submits the subject of legislation to do more to reduce illegal immigration by, among other things, creating criminal offenses for illegal entry into the state from a foreign nation and illegal reentry or presence following removal, and providing identification of public officials, employees, or contractors in connection therewith. The application of Section 5104 Penal Code as added by the bill is tied directly to the acts of a person who fails to comply with a peace officer's order of removal. Sections 117.003D and 117.004 of the Civil Practice and Remedies Codes as added by the bill are tied directly to providing indemnification of the proclamation's covered classes. The proclamation confines the business to a particular field, which may be covered in such a way, as the legislature may determine. Thus, the proclamation is not required to detail every element of the proposed legislation. Here, the complained of section are directly related to the major elements specified in the proclamation. Accordingly, the point of order is respectfully overruled. Mr. Spilly may continue. Ms. Niabi-Corrado, for what purpose?
Thank you. Does the gentleman yield?
Yes.
The gentleman yields for questions.
Thank you. Mr. Spiller, at the hearing in State Affairs on this legislation, there was no witness testimony from a lawyer that stated that House Bill 4 was constitutional, correct?
Could you repeat that question?
There was no witness testimony from a lawyer at the State Affairs hearing on House Bill 4 that stated that your bill was constitutional. Is that correct?
I can't recall. I did not invite any lawyers to come give their opinion, but I can't recall.
Well, I can tell you that there was no attorney who said it was constitutional. In fact, every practicing immigration attorney stated that House Bill 4 had likely had constitutional violations. But I want to discuss a certain provision of your legislation, the deportation sections starting on page 2, line 17. So it states that in subsection E, a peace officer may, in lieu of arrest, remove a person detained for a violation of this section, and then it goes through 3 different provisions, correct?
Yes.
So, and the peace officer would include DPS or county officers, local city police officers, even down to a school resource officer. Is that correct?
Yes, it's all law enforcement officers, as that term is defined under the, I believe, the Code of Criminal Procedure.
Okay, and that discretion of those peace officers to take this action of removal is entirely at the will of the peace officer, correct?
Yes, I assume that they would have discussions with other law enforcement officials. I can't imagine those decisions being made in a vacuum, but yes, they have that ultimate authority.
Okay, and your bill doesn't have any specific language or provisions regarding when the peace officers would need to take that action or make that choice of either arrest or removal, correct?
Correct. They would make that determination, presumably after discussions with others, maybe prosecutors, maybe DPS, maybe other law enforcement authorities, to make a determination of what they do in this particular instance. And the good thing about this bill is that it gives law officers discretion and the ability to make choices, whether they seek to have someone removed, whether they want to have them prosecuted, or whether they choose not to prosecute at all.
And I think you hit on a significant point, because you said that it would be generally after consultation with either prosecutors or other experts, right?
I would think so.
Because the determination that they're going to make about alienage on the first page, which is one of the elements of the offense, is a complex determination, right?
Well, I think it's a decision that's made on an individual one-on-one basis. You may have a situation where you have someone, a parent and a child. You could have some men that, I mean, certainly they need to check into it and see, look, are these folks that are here, if they have previous criminal histories, if they're documented terrorists, if they're on the FBI terror watch list, or whether they, and if you have a child, would the child and the parent certainly together be returned. So all those things, I think, would be made by law enforcement, and I trust them to make those decisions.
Right, so it wouldn't be an easy decision that they could maybe make on the spot, right?
Well, they could make it on the spot, or they could certainly go to some law enforcement facility. I don't think decisions have to be made on the side of the road if that's where they encounter them, or crossing a field if that's the instance. But I think certainly at some location they can make those determinations, yes.
But there's a lot of factors for them to determine whether a person is a quote-unquote alien under your statute, correct?
Correct, and I think law enforcement generally makes judgment calls in the field, or certainly after a stop or a detention in virtually any instance, and make a decision. Do we charge this person? Do we not? We take them into custody? Do we write them a ticket and with a promise to appear? There are any number of things that they may take into consideration.
Right, and so they may not make that decision right away. Let's say that you have a United States citizen who doesn't have proof that they are a citizen, like they don't have their passport with them, they don't have a copy of their birth certificate with them. What happens in that circumstance when you have an American citizen who an officer suspects may be violating this new sweeping state crime.
Okay. I don't know of a single instance where a U.S. citizen has been, even under federal law, under 8 U.S.C. 1227 or under 8 U.S.C. 1225, that has been removed from the state of Texas or this country.
But that wasn't my question.
Wrongfully.
My question is, what happens if a United States citizen is stopped by an officer who's a citizen, like they don't have their passport with them, they don't have a copy of their birth certificate with them? What happens in that circumstance when you have an American citizen who an officer suspects may be violating this new sweeping state crime?
Okay. I don't know of a single instance where a U.S. citizen has been, even under federal law, under 8 U.S.C. 1227 or under 8 U.S.C. 1225, that has been removed from the state of Texas or this country.
But that wasn't my question.
Wrongfully.
My question is, what happens if a United States citizen is stopped by an officer who suspects and they cannot prove that they are an American citizen? And an officer has to make a determination of whether this person that's stating they're a citizen is actually a citizen or not. What happens in that circumstance to a United States citizen?
Well, I'm just saying I doubt seriously that that's going to happen. People, if they're citizens, can usually say, look, this is my driver's license number, this is my date of birth, this is my name, this is where I live, this is where I go to school, this is where I work. I mean, I can't imagine this bill is not directed toward deporting or removing U.S. citizens. I don't think that's the purpose of the bill at all.
And the problem is, while you cannot imagine it, that has happened before, where United States citizens that cannot prove their citizenship have been detained, and so you have violations, potential violations of the United States Constitution that United States citizens can claim that, which I figured that's why you had those indemnification provisions to protect the counties, right? If something like that were to happen from all the lawsuits that can be filed in those circumstances?
I would say, first of all, under the federal statute, the federal government removes people that are here illegally on a regular basis. As a matter of fact, from 2016, 17, 18, and 19, the federal government averaged 328,000 removals a year.
But those weren't my
I don't know of a
questions.
single instance where any U.S. citizen was wrongfully removed from our country.
Well, I may remind you about Operation Wetback, where American citizens were deported by the thousands back to Mexico by the federal government. So this has happened, and it's an open sore and an open wound for people of my community, and which is why we're raising these concerns. But I do want to talk about another issue. What happens if Mexico does not accept the return of a non-Mexican migrant at the land port of entry?
Okay. And what I think is they're just like we have 50 states, Mexico has 32 states. 4 of those border Texas, and our governor has memorandums of understanding on border security where they have agreed to cooperate and fully cooperate with us in border security matters. And my understanding is that they will abide by that, they will comply with our requests, and that won't be an issue. If it is, then we'll deal with it accordingly. But we have every indication, based on the Governor Abbott's memorandum of understanding with each of those states, that they will cooperate with us.
I'm glad you brought up the MOUs, because that was raised at the hearing, and we researched and looked into this. And in fact, these MOUs with the Mexican states of Chihuahua, Nuevo León, Tamaulipas have no language accepting migrants from Texas. And in fact, were you aware that any such type of agreement would be required by the Mexican federal government? So they have laws. It cannot be negotiated, the state of Texas with these border states. It has to be any type of agreement where a country is going to take migrants has to be negotiated between the federal government and the federal government of each state of Mexico and the United States. So those MOUs, with all due respect, Representative, do not give the authority and would not be able to give the authority. So that's a big issue that we have to address about what's going to happen to these Mexican migrants or non-Mexican migrants that are not accepted by Mexico.
Okay, well, let me say this. I respectfully disagree. And under the 10th Amendment to the U.S. Constitution, Texas reserves and has certain rights to contract with and to work with the states of other governments. And I believe that Governor Abbott had full authority to contract and do a memorandum of understanding. I've read those agreements, and I frankly believe that it is done in the spirit of cooperation. They have pledged to assist us in border security matters. No, I don't think that the idea of removal and then accepting, we didn't have House Bill 4 at that time. I think that those agreements will be revisited, but I don't have any doubt that Governor Abbott will be able to work that out with those folks. But thank you.
Mr. Speaker?
Ms. Morales-Shaw, for what purpose?
Yes, I respectfully raise a point of order against further consideration of HB 4 based on Rule 4, Section 32C1.
Please bring your point of order down front. Ms. Morales-Shaw raises a point of order against further consideration of HB 4 under Rule 4, Section 32C1 on the grounds that the background and purpose statement is substantially or materially misleading. Ms. Morales-Shaw alleges that this statement that the bill creates criminal offenses that can be enforced by all law enforcement officials in Texas is misleading because the term officials is vague and may or may not refer solely to elected officials. The background and purpose statement may use terms colloquially as they are understood by a reader of average intelligence, and that use neither substantially nor materially misleading. Here, the statement does exactly that. Thus, it complies with the rule. Accordingly, the point of order is respectfully overruled. The chair recognizes Mr. Metcalf for an announcement.
Thank you, Mr. Speaker. Members, there is dinner for purchase in the members' lounge. I believe Gabe has made fried chicken for purchase. Thank you.
Members,